Hello, everyone. Thank you so much for joining us. We will go ahead and get started in just a second. Just wanted to give a second for people to trickle into the Zoom call. All right, I think everybody that was in the waiting room is in the call. Hello everybody. Thank you for joining us for our Navigating Mainstream Benefits training series. Today is day 2 of our training on SSI and SSDI. So a really quick intro for myself. My name is Sarah. I am from Homebase. Homebase is a nonprofit technical assistance provider. We provide TA for CoCs across the nation, and we work closely with Santa Clara County's Office of Supportive Housing. And one of the main things we do in that scope is bring you trainings on behalf of OSH, including this training on navigating mainstream benefits. Just want to make sure I'm letting folks in. Yeah, so we're constantly looking to improve our trainings, and we will be giving out a feedback form at the end of this training so that we can get a feel for what really worked for you, what you would like to see in the future. And so if you can take a second to fill that out before you leave the training today, it would be super helpful for us as it really helps us think about content development in the future. Okay, so today's training, like I said, is navigating mainstream benefits, and we are on day 2 of SSI and SSDI. I know we all know our Zoom rules, but it doesn't hurt to go over them really quickly. In terms of tech, all the training materials will be provided after the training, and they also go on the CoC website. This training is being recorded. When you joined in, you should have gotten a little notification. We are going to keep everybody on mute by default, just so that this training goes smoothly, but there will definitely be time for questions, and you can do that just by unmuting yourself or popping it in the chat at any time, and I'm happy to call that out to our presenters today. If you are having any tech difficulties, which I really hope you don't, but if you are, feel free to ping me, and you can also email us at the Santa Clara email, or email Sadika, whose email is also listed on the slide. Alrighty. So getting into our little icebreaker. We would love to know who's in the room with us, and we also think it's a good way to get familiar with the Zoom chat feature if you aren't already. Please tell us who you are, what organization you're here on behalf of, and do you prefer coffee or tea? We'll give it a second as responses come in. Okay, I see some responses coming in. I really appreciate the participation. Keep them coming. It's always great to see who all is in the room with us. I will go ahead and get our next few slides queued up so that our presenters can begin. Give me one moment, please. Alrighty. Can everybody see that? Okay, I'm seeing a few nods, so that sounds good. Okay, so without further ado, I will hand it over to our presenters.
Hi, everyone. My name is Charlotte Tran, and I just wanted to do a brief introduction before we begin. I'm a staff attorney with the Law Foundation of Silicon Valley, and with me presenting is Rachel Mino. She's our supervising attorney. We are both from the health program at the Law Foundation, and we're really excited to present for you today.
Thanks. I'll introduce myself briefly, and I'll be on camera in about 2 minutes. I'm just coming home from a lunch function, but my name is Rachel, as Charlotte mentioned, and I'm the supervising attorney with our health team, and we're pleased.
Okay. And then we can go ahead and move on to the next slide. Okay, so just a little bit about our organization. So the Law Foundation provides free legal services in 3 subject areas: in health, in housing, and in children and youth. Like I said before, Rachel and I are from the health practice, and we provide legal services to people living with physical and mental health disabilities in a variety of practice areas. And that includes mental health patients' rights. We're patients' rights advocates. And help folks with civil commitment hearings at psychiatric hospitals. We help people with public benefits, including Social Security and other local county benefits such as Medi-Cal, General Assistance, CalFresh, CalWorks. We also have some experience with helping students with federal student loan discharges, and we also offer name and gender marker changes through our pro bono law project. Next, please. Okay, so here's our training roadmap. Today is part 2, so we're touching on post-eligibility issues, including health insurance that's tied to Social Security benefits, both SSDI and SSI. We're going to talk about representative payees, also about living arrangements and how that can affect SSI benefits. There's also continuing disability reviews for beneficiaries that are receiving benefits. What happens when a beneficiary is incarcerated and how that affects their benefits. We are also going to talk about what happens if you work while you receive benefits. And then finally, we'll go over overpayments. And then I do see a question from Areli. Do you help with survivors benefits with appeals once they are denied? And so yes, we possibly could help with a denial of benefits, including survivors benefits. Okay, so before we get into all the rules and of Social Security, we just want to remind everyone that it is very complex. It's confusing for everyone, and the rules are constantly being updated and changed. So it's fine if you don't remember everything and you don't have to memorize everything. Our goal with this presentation is to just provide you with as much information as we can to help you identify issues that come up, and to help your clients identify those issues and when they should seek legal assistance. So if specifically if your client gets a notice from Social Security that they don't understand, we are here to help, and we can help the clients look at those notices. Okay. Yeah, so interacting with Social Security can be very difficult. They are incredibly backlogged, especially because of COVID. Not anything that we can fix, but just a system that we have to work as a part of. Thank you. Next. Okay, so the hard part is over. Your client was approved for benefits. And then now what? What are some of the things that they should be expecting? Next. Okay, so we'll talk first about insurance, health insurance that's tied to Social Security benefits. So specifically with the SSDI program, the Social Security Disability Insurance Program. Once again, it's for folks that have paid into the insurance, that have worked and paid into the insurance. An individual is eligible for Medi-Cal 2 years after their entitlement to SSDI. And entitlement to SSDI is 5 months after the date of the onset of the disability. So an individual is actually given Medicare coverage 2 years and 5 months after the onset of disability. And so although an individual may qualify, or an individual qualifies for Medicare 2 years after SSDI entitlement, their Medicare coverage may still come at a cost. For Medicare Part A, which is hospital coverage, if an individual is fully insured, meaning they've worked at least the 40 quarters, Medicare Part A is free. For persons on disability who are not fully insured, there is a premium of $278 per month if they've worked 30 to 39 work quarters, and a premium of $506 per month for people with fewer than 30 quarters. And also a deductible may apply for the coverage. For Medicare Part B, which is outpatient coverage, individuals typically pay a Part B premium of $174.70, and a deductible may also apply. Medicare Part D is for prescription drug coverage, and so premiums for Part D vary depending on the plan that the individual purchased, and Plan D also comes with a deductible. And so for those that are receiving SSDI who are low income, they may qualify for state-sponsored medical savings for a state-sponsored Medicare savings program, which will pay Part A and Part B premiums, the co-pays and the deductibles. Okay, next. And then now we'll talk about the supplemental security income, SSI, the needs-based program. An individual who is eligible for SSI is automatically eligible for and enrolled in SSI-linked Medi-Cal. After Social Security has approved an individual's application for SSI, Social Security will automatically report the individual's Medi-Cal eligibility to the local social services office. And individuals who are approved for SSI do not need to apply on their own, or do not need to apply separately. The Medi-Cal coverage will begin the same month that SSI benefits begin. So unlike SSDI, there's not a waiting period. If an individual qualifies for Medi-Cal through SSI eligibility, he or she will qualify for full scope Medi-Cal. Next. So now we'll move on to talk about representative payees. In some instances, Social Security decides that a beneficiary is a person receiving the benefits, the SSDI or the SSI. Social Security may decide that they're not capable of managing their benefits. And so if that's the case, Social Security will ask that a representative payee be appointed. Social Security recommends that it's a friend or a family member to serve as a payee. And if a beneficiary does not have a friend or a family member to serve as a payee, Social Security looks for a qualified organization who will serve as a payee. And these organizations typically will charge a monthly fee. At least in San Jose, there is only one representative payee organization. That's BMC, or Benefits Management Corporation. BMC typically charges beneficiaries approximately $40 a month to manage their benefits, and that fee is deducted directly from the beneficiary's Social Security benefits. Okay, next. So what is the role of a representative payee? What do they do? So the representative payee will receive the beneficiary's benefits payments directly. They are responsible for paying for the beneficiary's current needs, like housing and food and other bills. They have to save for future needs. They also provide the beneficiary with spending money. They also need to keep records and report use of the funds to Social Security. They also have the responsibility of looking out for overpayments and setting that money aside and returning the overpayments to Social Security. If a beneficiary has um, If a beneficiary has a representative payee, but feels that they can manage their own benefits, the beneficiary can file a request with Social Security to become their own rep payee. Um, and so the way that that works is the beneficiary will need to go to the local Social Security office in person um, and start the application process. They'll have to do that, yeah, in person and fill out the paperwork. Social Security will process the application and send a request to the beneficiary's doctor, asking if the beneficiary is mentally and physically capable of handling their benefits. Um, and so if you have a client that has questions about becoming their own representative payee, our office does have helpful information about this process, and we can provide that to you and your clients. Okay. So we'll now move on to talk about living arrangements for folks that receive SSI. Um, and so how much SSI a person receives each month is based on their living arrangement. So for SSI, it will be affected by a person's living arrangement. However, for SSDI, it doesn't matter where a person lives. The amount will always be the same unless there is an overpayment or some other reduction. So because of this, it's very important that clients on SSI notify, or on SSDI, but very much so for SSI, to notify Social Security every time they move, so Social Security can update their living arrangement. So typically, if a person lives independently, which means they do not rely on anyone else for help with paying their monthly expenses, and has their own cooking facilities, they should receive $1,182.94 a month in 2024. Independent living here, it includes the fact that the beneficiary is living alone, or they could be living with a spouse or minor children, and no one outside the home is actually paying for their food or their shelter. And if they are living with other people, they're paying the fair share of the food and shelter expenses. If a person lives independently and does not have access to cooking facilities, they will be eligible for the homeless rate, which is higher. A slightly larger amount to account for needing to purchase their meals, and to account for not being able to cook in the home. And that is $1,311.81 a month for 2024. Staying at a shelter may still qualify a person for the homeless rate if 3 meals a day are not provided to them at the shelter. Okay. So Social Security will reduce the amount of SSI a client receives if they live in another person's home and pay less than their fair share of food and shelter costs, or if they live in their own home or apartment, but someone else pays for all or part of their food, rent, or utilities. And so these are related to Social Security's rules about in-kind support and maintenance, which we'll go over in a little bit. Social Security will also reduce the amount of SSI a client receives if they are in a hospital or nursing facilities for 30 days or more. So it's also important to report hospitalizations of 30 days or more to Social Security. Okay. So we'll talk about in-kind support and maintenance now. So in-kind support and maintenance, or ISM, is food or shelter costs that someone else pays for someone who receives SSI. But it's important to note that federal housing subsidies and public benefits like food stamps and other assistance payments like home energy payments do not count as in-kind support and maintenance, and therefore will not affect the benefits of someone who received SSI. But shelter costs, including utility payments, do count. However, things like cell phone and cable bills do not count as in-kind support and maintenance. So under Social Security's ISM rules, if someone helps a client pays their rent, their mortgage, their food, or utilities, Social Security reduces the amount of their SSI benefits. For 2024, the monthly payment of SSI for people who SSA deems to receive ISM is reduced to $873.87. Generally, that would be the amount. However, there are more complicated rules about exactly how much SSI a person who receives ISM will be paid each month. But just for purposes of today's training, we're not going to focus so much on the exact amount of SSI, but we just want there to be the understanding that when there is in-kind support and maintenance, that it will result in a benefit reduction for beneficiaries. Next. Okay, so now we will go over some hypotheticals regarding in-kind support and maintenance. So we'll start with the first one here. Joe lives alone in his apartment. Joe's brother pays Joe's full monthly rent amount of $1,200. Will his SSI be reduced because of in-kind support and maintenance?
And I would encourage people just to put their answer in the chat if that helps.
Okay, so I see here that most folks have been answering. Many people have been saying yes. Yeah, so the answer is yes. Joe's SSI payments will be reduced because the monthly rent that Joe's brother is paying of $1,200 is counted as support, even though Joe lives alone in his apartment. Someone else is paying for that rent. Okay. All right, so we will move on to the second hypothetical. Oops, sorry. So Maria lives alone in an apartment with a Section 8 voucher that requires her to pay 35% of her income towards rent. She pays her full rent portion on her own using her SSI money. Maria's parents pay her cable TV bill. Will her SSI be reduced because of in-kind support and maintenance? Okay. I see here most folks have been answering no. Yeah, so the answer for the first part of this is no, and that's because the Section 8 voucher that Maria is receiving does not count as in-kind support and maintenance. And she is paying her portion of the rent using her own SSI money. While Maria's parents are paying for her cable TV bill, that doesn't count as in-kind support and maintenance. And so her SSI will not be reduced. Okay, and then what about the second part? What if Maria's parents also pay her PG&E bill or buy her groceries. If that were the case, would her SSI benefits be reduced for in-kind support and maintenance? So yes, so while cable bill assistance does not impact SSI, the PG&E bill and groceries, those two payments, if made by Maria's parents, would affect her SSI and would reduce the monthly amount that she would be getting. Okay. And then let's go on to the third hypothetical. Brandon lives with his brother and two sisters in a home that his brother owns. The mortgage payment is $3,000 a month. Utilities are $300 a month. And household food costs $600. The total household expenses are $3,900 for 4 people. The first part is, what is Brandon's fair share of the household expenses?
I will give one tip, which is to divide the monthly expenses by the total number of people paying those expenses.
Mhm. Yeah, so the total household expense is $3,900. You would be dividing that by 4 people, and that would be $975. That is Brandon's fair share of the household expenses. The second part is, will Brandon's SSI be reduced because he is receiving ISM? Well, here I think we'll need to consider if Brandon is receiving in-kind support and maintenance. If Brandon is paying his fair share of the household expenses of $975, then no, his SSI will not be reduced. But if that is being absorbed by his brother and 2 sisters, and he's not contributing, then his SSI will be reduced. Okay. All right, so we can move on to the next slide. Oh, okay, I think that's it. Yeah, we can move on to the next slide. Okay, so now we'll talk about continuing disability reviews, or CDRs. Social Security typically conducts CDRs every 3 years, but they may decide to do so more frequently if it looks like a disability is expected to improve. Social Security will notify clients by mail that they are reviewing their disability, and clients will have to fill out new questionnaires similar to the disability report, the function report that they filled out during the initial application. And similar to the initial application process, there's 2 levels of appeal, and that would be the request for reconsideration level, and then to appealing to the administrative law judge, the ALJ. Okay, next slide. Okay. So if Social Security determines that a client's disability has ended, it will send a written notice called the Notice of Disability Cessation to the beneficiary. Um, and so it's important that we take note of the quick deadline for appealing and continuing to receive benefits while the appeal is pending. And so that deadline is 10 days plus 5 days for mailing, total of 15 days for the beneficiary to appeal in order to get aid paid pending. Do everything possible it is to help the client submit the appeal within these 15 days to avoid a lapse in benefits. Also though, if 15 days have passed, there is good cause for late filing. That's allowed, but that may result in a lapse in benefits for the period of time prior to when the appeal was submitted. So please refer to the Law Foundation if your client needs help with filing a late appeal of a disability cessation. Otherwise, the deadline for appeal to get to the request for reconsideration level is 65 days. So 60 days plus 5 days for mailing. Okay. And then we will talk about what happens to benefits when a beneficiary is incarcerated. And we'll start first with SSDI benefits. SSDI and SSI payments generally are not payable for the months when an individual is incarcerated. If a client receives SSDI benefits, the client's benefits will be suspended if they are convicted of a criminal offense and sent to jail or prison for more than 30 continuous days. So they'd have to be convicted of a criminal offense. Pre-conviction incarceration does not count. And incarcerations for probation and parole violations do count from the date of the order revoking probation or parole. For SSDI beneficiaries, their benefits can be reinstated starting with the month following the month of their release. And though clients cannot continue receiving SSDI benefits while they are incarcerated, the benefits that their spouse or their children receive will continue as long as the spouse and the children are eligible. Okay. Next slide, please. Okay. And so for SSI benefits, if a client is receiving SSI benefits, their payments are suspended if they are incarcerated for a full calendar month. And so unlike with SSDI, whether or not there is a conviction does not matter. As long as the beneficiary is incarcerated, their payments will be suspended. And their payments can be reinstated in the month they are released, unless the incarceration lasts for 12 consecutive months or longer. And so it's important for the client to tell Social Security about when they are released after a period of incarceration and to provide documentation of the dates of incarceration. Because if it's less than 12 consecutive months, then the beneficiary can continue to receive their benefits. But if a beneficiary is incarcerated for 12 months or longer, they have to reapply for SSI benefits. Okay. And now we'll just pause a few minutes for any questions. And then Rachel will take over with the second part of the presentation.
And feel free to unmute yourself and ask the question verbally or put it in the chat. We'll just wait 2 minutes to see if anybody has questions, but anybody has any questions before proceeding. Okay, maybe 2 minutes is too long to wait. That's a lot of silence. Okay, well, if you have any questions, oh, great. What is the title of the SSA 8203 form? I don't know that off the top of my head. 1 second. Let's look that up. Okay. Oh, it looks like the 8203 form is a statement that a person can file in order to prove that they are still eligible for continuing SSI benefits. And I'm sorry, I don't, SSA 8203, yep, it must be something that somebody fills out when they're going through a recertification or a CDR, and Social Security is trying to determine if the person is still eligible for SSI. They may have them come in for a recertification, and in doing so, they may fill out a statement to, swear to or state that, their income and assets haven't changed, or they've only, changed slightly and they're still eligible for SSI. So here, and I'll even, oh, that's not a great copy. I was going to say the easiest way to do it is if you go onto Social Security's website, or even if you just use Google and you Google it, you'll be able to find a copy of the SSA 8203 form. I will caution you not to use any forms where they ask you to pay for them to use, because they should be free on Social Security's website. So, lots of times when you search for forms like that, you'll get companies coming up being like, we can help you fill that form out for a low price. Like, don't, you don't need to. It's easy to print off a Social Security's form. Okay, and then there's a question, what if a client who lives with his spouse is still working, then will SSI reduce? Yes, so if a person is living with a spouse and the person's on SSI and his or her or their spouse is working, some of the spouse's income is attributable to the SSI recipient, and so Social Security will take into account the unearned income, meaning it's unearned by the SSI recipient, it's earned by the spouse, but they will take that into account, and it may impact the person's SSI benefits, and their benefits can be reduced depending on how much their spouse is earning. So yes, it's really important, and Social Security will ask, are you married? Do you have income from other sources? And we'll take that into consideration when determining whether a person gets SSI and how much SSI they get. So for example, I had a client, I don't currently have a case open for her, but her husband worked part-time at a community college working in the cafeteria, but his income was not steady, but he'd get some month and some not the next month, or less the next month, and maybe more the next month. And so she was continuously reporting to Social Security to make sure Social Security knew exactly how much her husband's wages were every month, so they could properly calculate the SSI benefit that my client was entitled to. So it is important that Social Security is aware of a spouse's wages. And then, so as far as a spouse's income, no, that is not applied to SSDI. And that's a great question. And that is because I know we talked about this in last week's presentation, and it really comes down to the difference between SSDI and SSI. SSDI is a benefits program or an insurance program that people are entitled to because they've paid into it. And so other income in their household does not disqualify them. All they need to do is show, I've worked a certain amount of credits or worked a certain amount of time, have a certain amount of credits built up with Social Security, and I'm no longer able to work due to my disability. And then they get SSDI benefits. It is an insurance program. And so it's not impacted by somebody else's earnings in the household. However, SSI is a needs-based or a welfare benefit. And so you only get as much as you're entitled to based on other sources of income that are coming into your household. And so a person's, like a family member's or a spouse's earnings do impact your SSI, but they do not impact your SSDI. That's a great question. Okay, we'll go to the next slide, and feel free to put questions in the chat. I know Charlotte will tackle them as she can while I'm speaking, and then we'll also have another segment for questions as well. So as Charlotte mentioned at the beginning, this presentation is focused on issues that come up after a person's been found eligible for either SSI and SSDI. One of the main issues that comes up is people's interest in or attempts to work while receiving either type of benefit. And so one of the standards of just getting on SSI or SSDI in the first place is you can only receive those benefits if you're unable to work and earn above what's known as substantial gainful activity, or SGA. So if somebody can earn more than $1,550 a month through employment, SSA will say you're not disabled, even if you have disabling conditions. And that 1,550 a month is what is known as SGA, or substantial gainful activity. And I know we talked about last week how that amount can vary. So every year it goes up a little bit to account for inflation. So that 1,550 will be higher in 2025. But right now, Social Security wants to know if somebody can earn 1,550 a month or more, in which case they're not going to be entitled to either SSI or SSDI. But Social Security does say, well, we've got certain limited protections because we want you to try to go back to work if you think you can, because maybe you don't want to be on benefits forever, but you needed them for a year or 2 or 3 years because you had a disabling condition, and now you think you might be able to go back to work. Let's see if we can try it out a little bit before we totally cut you off of SSI or SSDI. And so there are really important work rules to be aware of when a person is on either of these types of benefits. Each program has different policies, and we're going to talk about the policies for each benefit program. So next slide. We're going to start with SSI because the return to work rules and what happens when you're working are less complicated than the rules that apply when a person is on SSDI. So what happens is if a person is working and receiving SSI, they will need to notify Social Security of their work. And I'm going to give you an example. I had a client who was receiving SSI, but he did some part-time work in the gig economy. He had an electric bike and he would work for DoorDash and take DoorDash orders and drop food off and get paid. Not earning a lot of money, but he's earning some. And he needed to report that money to Social Security, and he did. And Social Security would take a look at those wages and say, thanks for reporting. Let's see how much that impacts your SSI benefits. So first, what SSI will do is take the person's wages for that month. So for example, let's say my client who delivered for DoorDash made $400 in a month doing DoorDash deliveries. They would take the gross monthly earnings. That means they want to know how much that client was receiving before taxes. They automatically subtract 85. So they say, okay, great. We're not going to count the first $85 you earn at all. So let's say you earn $400. We're going to subtract 85. That takes us to 315 of countable earnings. And then Social Security is going to take that 315 and divide it by 2. So actually, let's use the example that I've highlighted below. Let's say my client made $500 per month because the math is just a little bit simpler to walk through in a presentation. Social Security will take that 500, subtract the 85 off the top, which leaves the client with $415 a month that Social Security needs to take account of. Granted, the client still earned 500, but Social Security is only counting 415 of that 500. And then Social Security is going to divide that amount by 2, which leaves us with $207.50. And that's the amount by which Social Security will lower my client's SSI payment. So if my client earns $500 a month working, Social Security is going to say, great, you can still get SSI, but we're going to reduce your SSI by $207.50. And so, previously, let's say, for example, client's SSI benefits are $1,000, subtract $207.50. That client's now eligible for $832.71 a month for SSI, although Social Security just rounds down. Even though you feel like you should be rounding up to 833, Social Security always rounds down. And so that client would receive $832 a month in SSI. So you can see where it's sometimes, really helpful for clients to be able to get SSI benefits and work a little bit, because yes, this person's SSI payment went down by $207, but the client brought in $500 in earnings. And so it may be beneficial to the client to work a little bit as well as receiving SSI benefits if the individual is capable of doing so. It's important, therefore, for clients to always report their wages to Social Security. Social Security is going to send a client a check 2 months after the client earns the SSI. So for example, a January check is not sent till March. So when a client gets a check in January, that's actually their November benefits. And so if the client reports their wages in January, they're not going to see the change to their SSI benefits as a result of those wages until March. This can sometimes result in overpayments. Sometimes it can result in underpayments. And so we always ask clients to be aware that, when you're working and you're on SSI, report the wages as quickly as you're possible. And if it turns out you earned too much and you got paid too much SSI, And then, you know, just be aware that Social Security may tell you that you have an overpayment of sorts. And thank you, Sarah, thank you, Charla, for the deduction information. That's very helpful. Okay, next slide. So we talked a little bit about this on the previous slide, how important it is for a person to report their wages when they're receiving SSI and earning some income. And so if a client is working while receiving SSI, it is very important that they report those wages by the 10th day of the following month. So if a client has wages in January, then the client should report to SSA what their wages are by the 10th of February. And Social Security will then take that wage information and adjust upcoming payments accordingly. And therefore, 2 months following that, the client will get SSI benefits that account for the fact that the person may have had some wages 2 months prior. If a person reports after the 10th day of each month, that can really amplify the potential for having an underpayment or an overpayment. Underpayment is not the worst. You know, you will get a person, if they're underpaid SSI benefits, that will be made up by Social Security. Overpayments are more troubling because then clients have to worry about paying the Social Security back for making too much SSI. And that can be troubling to keep account of or to even have to pay back. There's a couple of ways people can report their wages to Social Security. They can take their pay stubs in person to the Social Security office. We always recommend that if you take your pay stubs in, you bring in 2 copies and you get a date stamped by Social Security to prove that you've brought that pay stub in. You can also have your clients download this smartphone app called SSI Mobile Wage Reporting, and they can report their wages on the app. You could fax it in or mail it in. I'm always a little bit less certain that those are going to be, I'm always a little bit concerned that, you know, reporting wages by faxing or mailing stuff in might get lost in the shuffle. So it is an option, but I always recommend either in-person or wage reporting on the mobile app, just for security and safety and for knowledge that whatever you've turned in has been received. And if Social Security somehow loses it, you can always go back and say, hey, I did turn it in. Here's proof. Here's my date stamped copy. And then if a person stops working, always let Social Security know as well. Social Security needs to update their records accordingly. Okay, next slide. So let's run through a hypothetical. SSI return to work. So Tony receives $1,082.94 a month from SSI and he wants to try to go to work. He gets a job as a peer mentor at a local agency. So let's take a look at his wages from the year of 2024. They varied. He's a peer mentor at a local agency. Maybe some months he works more than others. So in January, he makes $800, February, $950, March, $1,000, April, $1,300, $1,580, $1,400, $1,400, $1,400, $1,400. Those are his wages for the year. And remember, if you're earning more than the SSI rate, then you're not going to be entitled to SSI payments at all. So just using the chat, can you type in what months you think that he's automatically entitled to an SSI payment, even if it's reduced? And I'll open my chat now. Yeah, so I'm seeing some different answers. So let's go month by month. In January, he only earns $800. He's not earning over SGA, so that's okay. February is the same case, as is March, and even in April. In May, we see that Tony has earned $1,580 a month. So he has earned over the 1,550 SGA limit, in which case Social Security is going to say, you're not eligible for benefits. You've earned too much. And they're not going to pay him benefits for those 3 months. That month, sorry, May. And then June, July, August, and September, he's earning $1,400 per month for those 4 months, in which case he is earning not quite SGA of 1,550, but he is earning more than the maximum SSI rate. And so he will not make any, or he will not be entitled to SSI for those benefit months either. So I think most of the answers said that January, February, March, and April, April's a little bit questionable because he's getting close to the max SSI rate, but those months he's probably eligible for something. Obviously he still has to report all his wages, and in the May through September months, he will not be eligible because he's earning over SGA in 1 month and he's earning over the maximum SSI rate in all the other months. So the second question is, will Tony's SSI be automatically terminated because he works over SGA? And I'm not sure we've gone over this in the presentation, so I'm just going to go ahead and answer and say no. He's not going to be automatically terminated because he works over SGA. He just will not receive benefits for that given month. And then he would obviously need to report ongoing what his benefits look or his earnings look like in future months. If Tony were to earn 12 months or more of income over the SGA limit, then yes, he would not be entitled to SSI anymore because he would have been working over SGA for over a year or longer. And what do you think will happen if Tony forgets to report some of these wages and he does not remember to do so until sometime later? What is the possible adverse result of doing so or failing to report? Yes. Correct. Seeing Vanessa and Maria with their answers in there, Esther with their answer in there. Yes, he's potentially going to face an overpayment. And Social Security we'll talk about overpayments shortly in the presentation, but Social Security does not always calculate overpayments them right away. And so sometimes it can be months, if not a year or two before Social Security says, whoops, we paid you too much 6 months ago or 8 months ago or a year ago. And then overpayment results, which we'll talk about in more detail towards the end of the presentation. All right, next slide. So we went through SSI first because SSDI return to work rules are more complicated. And I will caution you all that the information I'm going to share on the next few slides, please don't try to memorize it. It's very complicated. Why we present this to you is so that you can kind of issue spot and say, gosh, I'm working with a claimant who seems to have some trouble with Social Security. It's like they're trying to work. Maybe they have worked. They're getting notices from Social Security saying, oh my gosh, you're not going to get benefits anymore because of your work. And then maybe it just for you kind of allows you to issue spot and see that there is maybe potentially an SSDI and a work issue, and that it's something you could then refer to our office. So just to begin the complicated process, returning to work when you're an SSDI recipient has several steps. The first step is what's known as the trial work period, which we sometimes call TWP. The next step is the extended period of eligibility called the EPE. The next step is the expedited reinstatement period, EXR. And then once somebody has been expeditedly reinstated onto benefits, they get an initial reinstatement period and a new trial work period, et cetera, et cetera. And it can cycle on over and over again, potentially for certain clients. So let me delve right into it and try and break down each of these steps as best as I can. Next slide. So let's say somebody's on SSDI and they think they might be able to go back to work or they want to try working again. There are return to work rules. And the first of those is that a person who's on SSDI gets what's known as a trial work period or a TWP. What the TWP allows is for a client on SSDI to test their ability to work for at least 9 months without any consequences for their benefits. So during this 9-month trial work period, when a person's getting benefits and also trying to work, the client will receive their full SSDI benefit regardless of how high their earnings are. So unlike SSI, where it's like, gosh, if you had too much, your SSI is going to get reduced a bit. If you get SSDI and you're in your trial work period, TWP, you can earn as much as you want with no consequences at all for your SSDI benefits, as long as you are reporting your income and you continue to have a disabling impairment. Obviously, if you no longer have a disabling impairment and you're just going back to work, your benefits are going to stop. But if you're still disabled, you can work for 9 months and get your full SSDI and your full work earnings without any consequences. The trial work period starts, and this is a new number I'm going to throw out at you. The trial work period starts the first month a client earns over a certain amount in gross income. It is not the SGA amount of $1,550. It is $1,110. You don't have to worry about the numbers from the past unless somebody's getting a notice about an old trial work period ending. But in 2024, if a person earns $1,110 or more and is on SSDI, they are using a month as a trial work period month. So the client can work and earn less than $1,110 and will have no consequences at all because they are not earning too much. They're not eating up their trial work period months. They can keep getting SSDI on and on and on. But as soon as a person earns $1,110 or more in the year 2024, they are using a trial work period month, of which they have 9. You have 9 trial work period months to earn over that 1,110, and still get your full SSDI benefits. Okay, next slide. So I'm going to make it a little trickier, and I'm sorry. Again, I don't want you guys to have to feel like you have to memorize these or be experts on this, but just so you understand that trial work periods and returning to work when your SSDI is complicated. And so when you see issues, please refer them to us. It does get tricky. The trial work period, as I mentioned, gives you 9 months in which you can work and earn over that $1,110 in 2024 and still get your benefits. But those 9 months do not have to be consecutive. So you could work 2 months here in January and February, and then work under that 1,010 in March, April, and May, and then work over your 1,110 in June, July, and August. That's fine. That's going to give you 6 months, even though those months are not consecutive. Maybe you don't work any more over your trial work period at all in 2024, and then 2025 rolls around, and that trial work period amount goes up a little bit, like maybe it's 1,130 next year. And then there's a couple of months where you make too much more than 1,130. Those add up and can be aggregated with the 6 trial work period months you used the year before. So as long as you accumulate 9 trial work period months within a 5-year period, even if those months are not consecutive, you have used up your trial work period. You can no longer work and earn more than the trial work period amount without a consequence for your Social Security benefits. The good news is that while you're working in the trial work period, your Medicare doesn't change at all. You will still be medically eligible. You will still be categorically eligible for Medicare, although you may, if you were receiving Medicare with certain state subsidies from the state of California, some of those state subsidies may go away, and so you may be responsible for more of your premium or copay or deductibles, but you will still be on Medicare during that trial work period month. Next slide. So complicated. Let's run through a hypothetical really quickly. Here are Gina's work earnings in 2024. And remember, I'm going to put this in the chat. $1,110 is the amount that if you earn that amount or more, basically counts as a trial work period month for you. So let's say Gina has the following work earnings in 2024. 1,200, 200, 1,600, 900, nothing in May or June. July and August, she has 1,150, 1,170. September, she has 975. In October, she has 890. November, she has 930. In December, she has 1,750. So if a trial work period in 2024 is any month in which you earn 1,110 or more, which of those months between January and December of 2024 are trial work period months? And I'll give everybody a minute because it's a lot to type in potentially.
Is this a potential poll question, I think?
I can't remember if this is a poll question. I don't think so, but you can click the poll and see if it comes up. I can't remember if this was a poll or not. I think we're maybe just gonna ask people to put it in the chat. And it looks like we're getting a lot of really good answers. So yeah, so in January, 1,200 exceeds the 1,110. That counts as a trial work period month. February, she's fine. She's only making 200, so she's well below the 1,110. In March, she's above the 1,110, so that's a trial work period month. And April, May, and June, she's making far less than 1,110. Those don't count. But in July and August, she makes slightly more than 1,010. So those count. We're now at 4 trial work period months that she's used. September, October, and November are fine. That's all below 1,110, but December, you see her earnings tick back up to 1,750, which is above the 1,110. So easy. How many has Gina accumulated 9 trial work period months? And if not, how many months has she calculated? How's she accrued? Yeah, thank you, Patricia. Yep. So she has accrued 5 trial work period months because there are 5 months in which she earned over 1,110. So she has not yet accumulated 9 trial work period months. She still has 4 more months that she could potentially work over the amount specified by Social Security and still get her full SSDI. Okay, next slide. Okay, so let's say Gina earns or uses up 5 trial work period months in 2024, as we just illustrated on the previous slide. And then she rolls into 2025. And again, hypothetically, let's say the amount then is 1,130. So any month in which Gina earns more than 1,130 puts her in a trial work period, and she uses those months up. And that in a 5-year period. Yes, correct. It does not have to be 9 consecutive months. It's just 9 months in a 5-year period or 60-month period. So let's say in 2025, she works 4 more months over the new amount of 1,130. So now she's used up her trial work period. What happens next? She can no longer work and earn over that amount and just get SSDI without any potential consequences. So what happens after the trial work period ends? Gina will enter her extended period of eligibility, EPE. The EPE is 36 consecutive months after the TWP ends. So you've got your 9 month of TWP where she's earned more than she's allowed to earn and not have a count as a TWP. So she's used up her last TWP month. And now right after the last TWP month, she enters 36 consecutive months of an extended period of eligibility. And in those 36 months, she will get her SSDI benefits as long as, and this is where we go back to SGA, as long as she earns less than $1,550 a month. So I think of it as a light switch that goes on and off in that 36-month extended period of eligibility. She may no longer get her benefits if she's earning too much, like she could in the TWP. But if she earns under the SGA amount of 1,550, she will get her benefits. And so Social Security will keep track every month. And Maria, that's a great question. You need to report so Social Security can be aware of what your wages are. And Social Security can say, yes, this is a month where you're under 1,550, light switch goes on, you get your SSDI. And maybe 2 or 3 months go by where Gina's earning under 1,550, that light switch stays on, she gets her benefits. But then the next month comes along and maybe she earns $1,800. And then the light switch goes off and she does not get SSDI benefits that month. And that will go on for 36 months. So the client will continue to get full SSDI benefits as long as the gross earnings are below the SGA of 1,550. But for every month that the client's gross income is under 1,550, they will get SSDI. Next slide. So as I mentioned, the EPE, the extended period of eligibility, is all or nothing, like an on and off switch. If the client earns above SGA, they're not going to get SSDI. If they earn under SGA, they will get their SSDI benefits. And what we try to do is tell clients, look, if you're in your extended period of eligibility and you want to keep getting SSDI, you want that light switch to stay on, we recommend that you don't get anywhere near 1,550, right? Don't jeopardize it. Maybe keep your earnings at 1,350. Can you work with your boss to maybe reduce your hours just to be on the safe side so that you can get your SGA, get your earnings. The earnings don't go above SGA and you can still get your SSDI. So let's say what happens after the 36-month period is over. After the 36 months are over, the first time the client earns over SGA, their benefits are stopped, with the exception of a 3-month grace period. So after the 36 months are over, let's say the client earns $1,800, which is well over SGA. That means that Social Security is going to say, great, you've used your trial work period, you've used your extended period of eligibility, and now you're making over SGA. You're no longer entitled to SSDI. You're going to get one more month, the month in which you earned over SGA, and a 2-month grace period, and then we're stopping your SSDI benefits. Overpayments can be really common during the whole period of EPE, and even after EPE, if Social Security is not quick enough to pick up on it and stop your benefits. So we tell clients to document all their work activity, keep all their pay stubs, and make sure that they're just keeping track of anything they may have potentially been overpaid in case they need to pay it back to Social Security. Okay, next slide. So let's say that we're going to do another hypothetical here, and we do these because this can be such complex kind of periods of time and numbers to kind of really keep track of to determine when some of these SSDI and work earnings are going to potentially cause a problem. So let's go through a hypothetical where Gina's 9-month trial work period expires in December of 2023. And we know that in 2024, the SGA amount is 1,550. So we know that her trial work period is up. And so any month hereafter, she's in her extended period of eligibility. So it's the on-off light switch. If she makes more than 1,550, she's not going to get SSDI. If she makes less than 1,550, she is going to get SSDI. So let's go with the first question. Looking at January, February, March, April, May, and June, what months did Gina go over the 2024 SGA rate of 1,550? Okay, correct. Yep, I see Maria and Luna said February and April. Nina says February and April as well. Ellen, February and April. Yeah. Adam, thank you. Esther, yeah. So perfect. That's the correct answer. In January, she was fine. She's below 1,550, but you see in February and April, she made 1,700 and 1,560. So those 2 months she did go over SGA. So what's going to happen? The light switch goes off and she's not going to get SSDI benefits for that amount. So with that information, what months in between January and June was Gina actually entitled to an SSDI payment? Yep, exactly. January, March, May, and June. Every month aside from February and April. And we're only looking at 6 of the 36 months of extended period of eligibility. And so for the next 30 months after June, Social Security will continue to treat Gina's eligibility for SSDI like an on-off light switch and pay attention to her wages to see if she's either under or over the SGA amount. And just be advised that SGA amount of 1,550 is just for 2024. So when Social Security continues to evaluate her entitlement to benefits for the next 30 months, that number will change in 2025 and in 2026. Okay, next slide. Okay, so as I mentioned, if a person has gone through, like our hypothetical person, Gina, has gone through their 9-month trial work period and used that all up, and then they've gone through the 36 months of extended period of eligibility, the on and off light switch, where they can or cannot get benefits depending on whether or not they're earning above or below SGA. And then the 36 months ends. The first month after that, in which Gina works over SGA, whether it's a month later or 8 months later or 2 years later, the SSDI will be terminated. So let's say the 9 months are up, the 36 months are up. Gina keeps going under SGA, so she's getting benefits for another 6 months, 8 months, 9 months, oops, and then the 10th month, her earnings are over SGA. Social Security is immediately going to say, okay, sorry, now your EPE is up and you've gone over SGA, your SSDI is being terminated. We're going to give you this 1 month plus 2 months of grace period benefits, and then you're no longer entitled to SSDI. You're off of the SSDI program. But what happens if Gina, because of her disability, maybe 6 months later or a year or even 2 years later says, I've been working and now I just can't work and earn over SGA anymore? Gina can then go in and file what's known as an EXR, or an expedited reinstatement. It is an application that is intended to be processed by Social Security faster than an initial application would be processed, based on the fact that Gina was previously on SSDI, used up her TWP and EPE, and now cannot work an over SGA again because she is disabled resulting from the same disabling conditions that she was previously approved for. So Gina can ask for EXR if her wages drop below SGA at any point within 5 years after the 36-month EPE ends. If it's more than 5 years after the 36-month EPE ends, then Gina would need to start a new application. But there are 60 months after the EPE ends in which Gina can take advantage of the expedited reinstatement process. It is like a new application for benefits with a few pros. It is somewhat faster than actual new applications. However, it's important to note it can still be a lengthy process because Social Security will do a new disability review. Less strict standards, but they want to make sure that Gina is still disabled and qualifying for benefits based on the same disability she was previously approved for. But another positive with the EXR is that unlike a new application where you don't get benefits while you're waiting for a decision, anybody applying on the EXR program gets 6 months of provisional benefits. So Social Security basically says, we're going to provisionally approve you for benefits and give you 6 months while we work on your application, your expedited application. And you're going to get those 6 months of benefits while we make a decision. If the application process takes longer than 6 months, and it sometimes does, the individual will not get payments during the months that it takes after the 6 months of provisional payments are up. So we always like to tell clients that so we can say, look, you're going to get 6 months of provisional payments, but it might take Social Security 8 months or 10 months or even a year to approve this. So I would be cautious with that money because there may be a period of time where you're not getting provisional anymore and you still haven't gotten a decision on your expedited reinstatement. The good news is that if Gina is approved after she's applied for EXR, she will get what's known as a new cycle of trial work periods and EPEs. But that cycle of new trial work period and EPE does not begin until she's been back on SSDI for 24 months. So it's not like you can get back on SSDI and then all of a sudden go, great, I'm going to work and use up a trial work period month. No, you have to be on your expedited reinstatement plan for 24 months before you get a new trial work period and extended period of eligibility. But EXR is a really helpful tool, and we've helped a lot of clients apply for Social Security disability benefits using the EXR tool, get some provisional payments into their pocket, and get them back on SSDI. All right, next slide. Just like I had said with SSI, if you're earning wages with SSDI, you must proactively report those wages to Social Security. You can walk in with your pay stubs, get them date stamped so you have proof that you've turned them in. You can report online if you have a my account on SSA, on my SSA account, you can go online and just report those. Unfortunately, unlike SSI, there's no app for reporting wages, so you either need to walk in and turn them in or use your online SSA account. Again, you could mail or fax them in, but I'm always a little bit skeptical that that's going to get processed properly, maybe probably more likely to get lost in the shuffle. And then, of course, as with SSI, we always want people to report to Social Security when their work stops. Next slide. So the bottom line for return to work, because I know the slides we've talked about regarding SSI and SSDI are complicated and lengthy. What we always tell clients is report your income when it's earned. Do not try to hide income from Social Security, especially if it's not under the table, because Social Security will conduct periodic reviews and pull IRS records. So they will be able to see whether your client has earnings. And we'll find out about it, and it's better they know sooner rather than later, because it's going to potentially result in an overpayment, and the longer it takes for Social Security to become aware of those earnings, the larger the overpayment could become, or even potentially you could be looking at a suspension of benefits for a period of time. So Social Security will find out about all taxable income at some point, sometimes sooner, sometimes later. And so we always tell clients report it as soon as possible. Next slide. I will pause here for questions because that was a lot of material. It looks like Charlotte answered all the questions too in the chat. Thank you for doing that. Just making sure. Looks like Charla answered everything. Thank you so much for that, Charla. Okay. Any other questions currently? Okay. Next slide. So I think our last topic for post-eligibility issues that we often see and handle on behalf of clients are overpayments, which we've already alluded to when we discussed, you know, potentially being incarcerated and getting paid too much while you shouldn't be on benefits, or working, or maybe you have in-kind support and maintenance that Social Security is aware of. All of those things can result in overpayments, and so that's what we're going to focus on next. So overpayments can occur for various reasons. When you talk about SSDI benefits, SSDI overpayments are typically caused, no surprise here, by an individual who goes back to work and earns more than SGA, and who's used up their trial work period and their EPE. And in that case, if you're going back to work and you're earning more than SGA, that's going to result in an overpayment. And as I said before, Social Security is not always great at tracking how much a person's earnings are, because they only do periodic reviews of IRS information about wages. So we always tell people to report their wages as soon as possible. Otherwise, it could be 6 months or a year, even sometimes 2 years before Social Security does a review and realize, oh my gosh, this person's been over SGA for the last 18 months. And their trial work period is up and their EPE is up. Now they owe us $25,000 back. And that can cause a really large overpayment. I have handled one case. This was the case where the highest overpayment I've seen, where my client had a $165,000 SSDI overpayment because she had not reported wages. Social Security had made so many mistakes. They kept telling her she was eligible and then not eligible. And they kept doing work reviews, but they kept paying her benefits. And like 15 years after the fact, they went through some huge concise analysis of her work and determined that she hadn't been eligible for like over a decade. We were thankfully quite successful in an overpayment waiver hearing, but it was tremendously burdensome and exhausting and stressful and anxiety inducing for the client. So all of that to say that SSDI overpayments are typically caused by work earnings. And so it's really important to try to report all your earnings to Social Security and keep on top of that, because I don't always trust Social Security to be as on top of it as they should be. And so you may be receiving benefits for years before Social Security determines that you had made too much and shouldn't have gotten the benefits, and then hits you with a very large overpayment. SSI overpayments are not typically caused by work nearly to the same extent that SSDI is. Lots of times overpayments can be caused by changes in living arrangements. So maybe you're getting the unhoused rate and then you become housed, but you forget to report that to Social Security. And then Social Security says 6 months later, gosh, you've been making too much. We gave you the unhoused rate and these last 6 months you've been housed. So now you owe us a portion of that back. Or maybe there's a change in income. That is, so maybe you are starting to earn a little bit as a DoorDash driver, or you're working part-time as a peer mentor, whatever it might be, and so you have a little bit of income. If that's not reported to Social Security right away, or even if it's reported but it takes them a couple months to process, that may cause an overpayment. If a person has excess assets, so all of a sudden Social Security finds out the person has 2 cars instead of just 1, which is otherwise an excluded asset or resource, they might say, hey, you've been on SSI for the last year and you've had 2 cars, so you've been over the asset limit. You now owe us all that SSI money back. If an individual leaves the country for longer than 30 months and continues to receive SSI, or becomes incarcerated and is incarcerated for over 30 months and continues to receive SSI, Social Security at some point will come back and say, you owe us that money back. So what should you do if a person receives a notice of overpayment? That individual has a couple of options. For how to challenge the overpayment. First, the person can file a request for reconsideration. And that's basically saying, no, I disagree with the overpayment. I don't have an overpayment at all. Or I agree there's an overpayment, but it is much less than you tell me it is. So maybe you say it's 5,000, but I actually think I was only overpaid by 1,500. So I'm going to appeal that. That is called a request for reconsideration. Next, a person can file a request for a waiver of overpayment. And that's basically an option when somebody says, well, yeah, I probably do owe that money back. There is an overpayment. I was working too much, or I did have excess assets, or I had left the country for over 30 months. but I can't afford to pay it back, and I don't think the overpayment's my fault. The person can file what's known as a waiver of overpayment. Finally, a person can file a request for change in repayment rate. Maybe they don't want to appeal, or maybe they don't even want to waive it. They say, okay, I know I owe $2,000. I want to pay it back. It is my fault. I can afford to pay it back, but I can't pay it back all at once. I'd like to pay it back at $10 a month or $15 a month. That person can file what's known as a request for a change in their repayment rate. So Social Security doesn't take out 10% automatically. They take out only $10 or $15 or whatever the person says they can afford to pay back. All right, next slide. So let's talk about the request for reconsideration, which is the first option I highlighted, and we'll talk about that in a little more detail. You can file a request for reconsideration, and that must be done within 60 days. And actually, it's technically 65 because there's a 5-day grace period for mailing. So you can file an appeal within 65 days of being notified of the overpayment. And again, an overpayment appeal or request for reconsideration is appropriate if the person disagrees with the fact of being overpaid at all or disagrees with the amount. And then when Social Security receives that request for reconsideration, Social Security will take another look at the reason for the overpayment and the calculation of the overpayment to make sure there's no errors, or if there are errors, that those errors are corrected. And then Social Security may reach out and say, okay, let's come in for a personal conference to discuss this overpayment to see if it's, if your appeal is correct and whether we need to be getting rid of this overpayment entirely or reducing the amount of it. If the appeal is processed and Social Security denies it and says, nope, we think you were overpaid and the amount is correct, and the client still thinks that Social Security is wrong, then the client has 65 days again to ask for a hearing with an administrative law judge, and then can go before an ALJ to make an argument about why he, she, or they are not responsible for this overpayment. Next slide. Okay, so let's talk more about the second and third options, the request for waiver or the change in repayment rate. Unlike the request for recon, which has to be filed within 65 days, unless there's good cause for late filing, a request for waiver or repayment rate can be filed at any time, even if the person started paying back the overpayment. They can say, well, I've paid back $2 of the $5,000, but I want to waive it now. I'd like to try and waive the rest and maybe even waive what I've already paid and get it back. Or I've been paying it back and I've been paying back $50 a month, but I can no longer afford to pay it back at $50 a month. So now I'm going to submit a request for repayment at $10 a month. So there's no deadline or time frame in which either of those forms need to be filed. They can be filed at any time. The waiver of overpayment, again, is an argument that the client is not at fault for the overpayment and cannot afford to pay it back. And then a request for change in repayment rate should be based on telling Social Security, here's how much I can really pay every month. Here's how much my income is. Maybe your income is still your SSDI, your SSI earnings, and then your expenses are such that it eats up most of your SSDI or SSI benefits, and all you really have left every month is $50, and so all you're willing or able to pay is maybe $10 towards that rate. So you want to show Social Security, here's really what I can afford to pay back. Social Security wants to try to collect everything back within 3 years, so they might say, well, you owe $5,000. And $5,000 divided by 36 months is X amount per month. That's how much we want you to pay back. And the person may say, that's way more than I can afford. I want to only pay back $10 a month or $20 a month. Social Security typically defaults to a withholding of 10% of an SSI benefit. So if a person is receiving the $1,300 a month, Social Security is going to go, let's take $131 a month. And the person might say, no, you can't take 131 of my SSI payments. I can't afford to live. Please only take $10, $20. So again, SSI, SSDI, I think I mentioned just above that they try to collect it within 36 months, but there is now a new rule that Social Security should be defaulting to 10% of the SSDI payment, just like they default to 10% of the SSI payment. Again, sometimes that's too much for a person to pay back, and they may say, no, I don't even want to pay back 10% of my benefits. I only want to pay $10 or $20 a month. And just like with the request for reconsideration, if Social Security denies either the waiver request or the repayment rate that the client has asked for, the client can ask for a hearing with an ALJ if they mail that request in within 65 days. And then they can go in front of an ALJ to argue that they are entitled to a waiver or that they're entitled to the repayment rate that they've requested. Next slide. Okay. So let's go through a hypothetical. As Sarah receives SSDI benefits in the amount of $900 a month and SSI in the benefits of $233.73. So she's getting SSDI and SSI, and she gets a total of $1,133.73 in month, which is the maximum SSI rate. So she's getting portion of the SSI, her benefits in SSDI, and the rest up to the SSI maximum amount. If she gets married, does she need to report her marriage to Social Security? Go ahead and put it in the chat. Yes, everybody is saying yes, and that's correct. Report your marriage to Social Security, especially because if there's income being earned by your spouse, they need to be aware of it. While Sarah is disabled and cannot work, her husband has a job and receives monthly paychecks. Does Sarah need to report her husband's earnings to Social Security? Yes, thank you everybody for saying yes. She should absolutely report her husband's earnings to Social Security. Sarah was previously married to an abusive spouse who lied and told Sarah he was not working and did not have any earnings. She continued to receive SSI benefits for the duration of the marriage. So once Social Security learns about Sarah's previous marriage and her current marriage and her ex-husband and her ex-husband's wages, this will probably impact her retroactively, will impact her SSI entitlement. If Sarah receives an overpayment notice saying, oh, we paid you too much because you were previously married and your husband had X amount of income, now you have an overpayment, what options does she have? What can she do now that she's gotten a notice of overpayment? What are her 3 options? Yes, she can ask for a waiver, absolutely. She could ask for an appeal. Might be harder to argue, but she could, and she can ask for a repayment rate. Henry says she can argue that she's no longer with the former partner and that they can't pay due to leaving an abusive situation. That's a great no fault argument and inability to pay it back. Yeah, waiver, appeal. She could obviously ask for a repayment rate if she's like, fine, I'm just going to pay it back, but I can't, do it at the rate that Social Security wants. What arguments can Sarah make if she files for reconsideration? She's appealing it and saying that there was never any overpayment at all, or the overpayment amount was wrong. Husband may have been in control of the funds. Yeah, I think arguments for the appeal are harder because there probably is an overpayment. So the existence or the fact of an overpayment is going to be difficult to deny. And the amount, if they've calculated it correctly, is going to be difficult to challenge as well. There could be some argument that she was not actually overpaid because she never actually knew her husband was working and therefore never received any benefit from him working, right? So if he was earning money and he never told her about it, so she never saw any of it or never used any of it for her benefit, then maybe it really doesn't count against her that he had earned income. And so maybe she really doesn't have an overpayment at all. And that's an argument she could make at the appeal or reconsideration. If she chose to use the reconsideration method. But I think she's got some better waiver arguments. So some people have already put some great thoughts in the chat. What arguments can Sarah make if she files for a waiver? And it looks like, oops, I scrolled to the top of the chat. Let me get back down. I think Henry Medina's suggestion about she's no longer with a former partner. And the arguments, the overpayment's not her fault because she didn't even know he was earning money. He didn't tell her he was abusive and she can't afford to pay it back. She left an abusive situation and doesn't have the money to pay it back. I think that's a great argument. Husband may have been in control of the funds again. So that I think even goes to both the appeal and the waiver argument. He lied about working. Yeah. So again, it's not her fault and she cannot afford to pay it back. And I really, encourage, again, if you see these issues coming up, to refer clients to us and to be creative. You can be really creative in coming up with arguments about why a client doesn't have an overpayment at all or shouldn't have to pay back an overpayment if one does exist. Next slide. All right, I think we're at questions. We may be close to, if not at the end of our presentation. Sarah, can you maybe just click ahead to see if, actually, is there anything? Yeah, let me just do the conclusion really quickly and then we'll go back to questions. When to refer cases to the Law Foundation. So if you were at the presentation last week and this week, or even just at today's presentation, it's a lot of complex rules that govern the administration of Social Security disability benefits. And so, again, these slides will be shared with you so you can keep them on hand at any point to refer back to them. But I think they're just mostly a guidepost for you to issue spot and think, well, when would this case be something I could refer to the health team for some additional help? So we will help at the initial eligibility appeal. So if somebody's filing for benefits, their initial application, we don't step in because there's no legal issue. It's just a logistical or paperwork issue of telling Social Security you want to apply. But if somebody is denied for either SSDI and or SSI, we can assist clients at that step by helping them file the appeal paperwork. And if they get denied a second time and they want to go to an ALJ hearing, we can help them file the paperwork for that as well. And at which point we would often do a merit review, meaning we'll look at all the facts of the client's case to determine if we're going to actually go to that hearing with the client. We ask you to remember that there's a 65-day deadline to appeal an initial denial or to appeal a reconsideration denial, and that's 65 days from the date on the notice. We don't assist with filling out initial applications, as I mentioned. We also help with benefit termination matters. So if somebody's already on benefits and they have a post-eligibility issue like the CDR that Charlotte talked about earlier, then we definitely help there. Do remember that with CDRs, if a person is being terminated from their benefits, they have only 15 days to appeal if they want to get their benefits to continue while the appeal is pending. Otherwise, they're subject to the typical 65-day appeal deadline. If anybody is getting benefits and their benefits are being reduced, you can refer them to us. And if anybody has any issues related to overpayments, please refer them to us. But do know that we have limited bandwidth. So for overpayments under 10,000, we may not be able to prioritize those cases. We may be only able to provide some counsel and advice and basic assistance. But for overpayments over 10,000, we can often offer more services, including potentially going to hearing if there's a strong case. I just would note the caveat that we cannot guarantee full representation to all clients in all matters. We do conduct merit reviews before agreeing to represent a client. And then we do provide varying levels of service, including counsel and advice, filling out paperwork, and full representation, depending on our analysis of the case and our bandwidth at the time. Next slide. I think that's it. And we how to refer clients to us. You can fax a referral form to us at 408-886-3850. You can email us at healthintake@lawfoundation.org. You can click the link for our tiny URL, so you can just do an easy online referral that goes directly to us. Your client can call our intake line. We've listed the number here. We also have walk-in hours at our office from every Tuesday and Thursday from 1 to 3 p.m. And that's located at 4 North 2nd Street, Suite 1300. So that's the 13th floor of our office, and we're in San Jose. The zip code is 95113. And then if your client utilizes Valley Medical Center and gets services either through the Valley Specialty Center clinics or through any of the VHHP clinics, we are often on site at those clinics. So we're at Valley Specialty Center at VMC every Monday from 1 to 4. We're at the Reentry Clinic in downtown San Jose, right near the criminal court and the jails. We're at the Reentry Clinic the first and third Wednesdays of the month from 1 to 4. We're at Hope Clinic the first and fourth Thursdays from 1 to 4. And we're at Alexian Clinic off of Alexian Drive on Fridays from 9 to 12. And I believe that sums everything up, and we can answer some questions. Looks like Patricia has a question about whether a levy can be placed on a client's Social Security survivor benefits. Survivor benefits, survivor benefits I'm not as familiar with. I know for SSDI and for SSI benefits, you cannot garnish SSI benefits. SSDI benefits, if there is an overpayment, and some of those, and the person's, because essentially what happens if you're on SSI or SSDI, they're going to, unless you get the overpayment waived or, reversed on appeal, that overpayment is going to exist. And if you're getting SSI or SSDI benefits, Social Security is just going to withdraw a portion every month to pay back that overpayment. So there wouldn't be a need to put a levy on, or to, I don't know if it's really called the levy. I'm not my area of expertise, but they can, maybe it is a levy, but they can put some kind of order on the bank to try to take money out of a person's bank account to repay overpayments. Social Security is, if a person's receiving SSI or SSDI, they're not going to need to do that because they're going to withhold automatically from the benefits. If a person gets an SSDI or SSI overpayment and is no longer on benefits, Social Security can, for SSDI overpayments, try to garnish wages or take money out of a bank account. And so I think they can, for SSDI overpayments, if the person is no longer on benefits, but gets wages from a job, they can try to garnish some of those wages or potentially take some money out of the bank account. And I'm not sure what, and I'm gonna caution you that I'm not an expert in like levies and consumer issues like this. So I can't answer that 100%, but I do know the Social Security has some tools when there's an SSDI overpayment and the person's no longer receiving benefits, and they can use those tools to garnish wages and potentially take money from a bank account as well. Are there other questions? And I think since we're done with the presentation, you can also feel free to unmute yourself and ask verbally if you want. Happy to hear voices if anybody wants to speak up.
Good afternoon. This is Maria from Sunnyvale Community Services. I'm a benefit specialist. Are you able to hear me?
I am, yeah.
Thank you.
Nice to see you.
You too. So a long shot question.
Sure.
With the whole presentation from last week as well as this week.
Yeah.
65-year-old, unhoused for 2 years because of a medical he didn't realize. He had access to more than 100,000 on 401k. We're just applying for Social Security disability.
Okay.
He just had the interviews for mental and physical. Question is, he doesn't have a primary doctor who is going to be able to respond to some questions because he's only been using the mobile van medical doctor. He does have Medi-Cal. We're trying to find a primary doctor who will accept him so that when his background research on his medical status comes up, he has a doctor. Does that make sense, or did I confuse the situation?
No,
Okay.
no. I guess my first question though is he's age 65?
Yes, plus.
Okay, because my first thought is if you're 65, if you're at or above retirement age, which he is, he wouldn't get.
Oh, I beg your pardon. I beg your pardon. He's 59.
Oh,
59.
okay. That changes everything.
Thank you. Thank you.
Because I was
Thank
like,
you.
I don't know how he's going to get disability. He should
No,
get.
no. You're absolutely correct.
Okay.
That's what happens when you have more than one case.
No,
59 plus.
I'm with you. Okay.
And
right.
he's actually been unhoused for 2 years.
Okay.
I just got him started on I just withdrew some money out of 401k, but now we have to house him. But more importantly, we have to help him get the Social Security disability eligibility.
And can I ask, do you think he's eligible for SSDI because he's worked recently? It's not been
It's been actually 2 years since he's worked because of the medical situation.
Okay. But he probably still he's probably still SSDI eligible because he probably hopefully he has enough work credits and he hasn't blown past his date last insured. But
yes.
Okay, so he's applying for SSDI, and then the question is about whether or not how he can get basically a primary care physician or a doctor to assist him so that they can fill out some questions like a mental impairment questionnaire or a
Correct.
yeah. And where does he has Medi-Cal, where does he currently get treatment?
He was, prior to a medical situation, getting it from Kaiser. For the last 2 years, he's been on a mobile van
Yeah.
at Trinity Church.
Trinity Church Mobile.
That's his, in other words, it's been the county mobile van, medical van.
And he doesn't have a primary physician, he just sees whomever is there, right?
That's correct.
Okay, so they are going to have medical records for him, which is good, right? Because he's been going there for 2 years, they do have documentation, but you're looking for somebody who knows him really well to fill out some additional questionnaires.
We're trying to get one, we're trying to get him back to Kaiser, not just the Santa Clara Bascom Valley Medical, system,
Okay,
because they have his medical records already.
yeah, okay. I mean, and that's gonna be helpful too, to make sure you let Social Security know that he has records at the van.
Yes.
As
yes,
well as at Kaiser.
Yes.
I wonder if there's a doctor at Kaiser that knows him well enough, even if he's not getting treatment there, that might be willing to fill out some of these questionnaires on his behalf. The other thing is, and it sounds like you're doing an initial application right now, is that correct?
Yes. Yes.
Okay, so what will also happen is if you're not able to find a doctor to kind of give some more detailed analysis, medical
Recent.
records.
Yes.
Yeah, recent, okay, some, medical records are still very helpful. You might reach out to the bus and see, if there's a physician there that's seen him frequently enough that somebody at that, at the van, sorry, I
Sure.
keep saying bus, but somebody at the van knows him well
Excuse
enough and has met with him, more than once or twice, maybe even 4 or 5 times, that even if he sees different people, there's somebody who knows him well enough that they'd be able to fill out that questionnaire. Otherwise, I think that hopefully he gets approved initial application, but if he doesn't, and he needs to go through recon, he's going to continue to build up relationships with doctors either on the van
Yes.
or if you can
Yes.
get him back
Yes.
into Kaiser. And
Yes.
at that point in an appeal, if he doesn't get approved initially, an appeal stage, he may be back at Kaiser and have a doctor who knows him well enough, or he may have built up enough credibility with other doctors at the van that somebody there will be willing to fill out that questionnaire. But I would at least start by asking at the van who knows him well enough that they'd be willing to fill that out on his behalf.
Excellent. Yeah, we'll go ahead and try that. Thank you so much.
And if he gets denied, you're welcome to refer him to us, unless that's a service you also provide, but we're always willing to help if we can, if it becomes a legal issue.
Sounds great. Thank you very much. And thank you for the presentations both weeks.
Thank you. I see a hand up with Conrad. You're muted. I don't know if you're trying to ask a question.
Right before we get into the next question, I just wanted to do a quick plug. The feedback survey is in the chat. It's just a really quick Google form, and we'd really appreciate you filling it out before you log off for today. Thank you.
Go ahead, Conrad, if you have a question. Okay. I don't think. Okay, I'm not hearing from Conrad. If anybody else has a question, feel free. Oh, sorry, Conrad. Okay, if you want, you can put the question in the chat unless it's a longer situation. It looks like, I don't know, Sarah, maybe he's trying to turn the speaker on. Too much for chat. Okay. Sarah, do you know if there's a way to get Conrad able to speak? Looks like
I'm not sure, but I don't think he's muted anymore.
Oh yeah. Okay, Conrad, can you say something? See if we can hear you. Shoot, I can't hear anything. We'll give it a minute and see if he's trying to figure it out. Oh, message failed to connect to speaker. Can you call in on your phone? Maybe? If you can look at the invitation, there'll be like a call-in number.
If you
I'm
click
happy-
phone
oh,
at the
go
bottom,
ahead.
that has a little arrow, and you click on that arrow, it will let you switch to phone audio.
And I know, Conrad, you're trying to get access to, speaker, or to audio, but I'm gonna just type my email in here in case if for whatever reason you're not able to get through, you can email me, or others can email me as well with follow-up questions. But we'll hang on a few more minutes to see if you can get through. Give it another minute. And actually, maybe I can just put my phone number as well. I have a client meeting after this, but Conrad, you could also call my number some point, either later today or tomorrow, if you wanted to talk, since I know it looks like maybe you're still troubleshooting.
I did just admit somebody calling in from their phone, so
Oh, yay! Okay, cool. If you're there, Conrad, feel free to use your phone to ask. You can hear me, okay. I can't hear you. Can you try speaking? I'm sorry, I can't hear. How about this, Conrad? I'm working from home right now, but I'm going into the office to meet a client at 3:30. So do you want to just try calling me either later today or tomorrow and we can try to troubleshoot your question? Maybe you can just put it in the chat if that works for you. Okay, thank you. I'm so sorry I'm sorry you're having audio difficulty, but we can talk on the phone. I'm out next week, so maybe try calling me tomorrow. That's probably best. Okay. Well, thank you. That's all we have for the presentation, unless anybody else has other questions or concerns.
thank you so much to both our speakers today. It was such a valuable and informational training. I appreciate all the time you've spent developing this content and coming out and answering all these questions. Thank you.
Thank you, everybody. Have a wonderful day. Bye-bye.